In this presentation, I briefly explained the meaning of the word probate. You can read many definitions of the word probate, but I think my definition may be the easiest to remember. Probate is the legal process of proving who is entitled to control and take possession of property after the owner's death. This definition is easy to remember. 5 P's: probate, process, proving, possession, and property. Probate is the legal process of proving who is entitled to control and take possession of property after the owner's death. The word property includes real property, that is, real estate and associated homes or buildings. The word property also includes bank accounts, investment accounts, life insurance policies, vehicles, boats, and other assets. Finally, property includes a variety of things such as books, tools, collections, musical instruments, furniture, art, and other personal property. After you die, various individuals are ultimately legally entitled to control or take possession of your property. It may seem obvious to you who is entitled to take possession of your assets. These individuals are usually your heirs or individuals that you have named in your will. But this may not be obvious to others who hold your property. For example, a bank may not be certain who is entitled to control or take possession of your bank account after you die. Your name is on the account, so now that you are gone, the bank has a question as to who is legally entitled to control or take possession of your account. It is critical here that you understand the following point in regard to this example. In this situation, your will does not help the bank. The reason is that the bank is not certain whether the will is valid or a fake. All they know is that your name is listed on the bank account and you are no longer present to control the account. The only valid legal ownership document, the bank account contract, then in existence, names a person who is now dead. So who is entitled to take control and ownership possession of the account? That question can only be answered in the legal judicial process known as probate. The heirs or potential beneficiaries of your property must prove to a judge that they are the ones entitled to control or take possession of your property. They are required by law to prove this to a judge in the legal court process known as probate. Remember, probate is the legal process of proving who is in fact entitled to control or take possession of your property after your death. Furthermore, after you die, if there is any argument, dispute, or conflict among your heirs or others regarding who is entitled to control or take final possession of your property, then again, probate is necessary. Remember the mantra: probate is the legal process of proving who is entitled to control and take possession of property after the owner's death. A few final summary points in this introductory presentation. There are several ways to proactively avoid probate. For instance, while you are alive, you can just give away your assets to beneficiaries. Or you can change your ownership documents, deeds, or bank account contracts, for example, and name as co-owners with you people you are sure to survive you. Those ownership documents will prove who is entitled to take possession of your property after your death. Or you can create beneficiary designations in various ownership documents, naming beneficiaries who will take possession of your property after you die. Or you can name and create a funded trust. There are significant advantages and significant costs or dangers to each of these methods, which we will briefly discuss in other presentations on probate. This concludes our introduction to probate. Thank you.